Okay, Mr. Leonardson, I'm just waiting for Mr. Thompson. He should be here any moment, so it'll just be a second. Okay, Mr. Leonardson, if you could unmute, and we'll go on the record. This is Corporal versus Patrino. This is case number 2311369. The record should reflect that both parties are present. Mr. Leonardson is present by Zoom on behalf of the defendant. Mr. Thompson is present here in the courtroom on behalf of the plaintiff. This is set for a final status conference. We do have this set for a half-day evidentiary hearing, which is scheduled to proceed on Friday, April 12th. Mr. Thompson, the court did receive your trial brief as requested by the court at the last hearing. Are you going to be prepared to go forward on the 12th?
Yes.
Mr. Thompson, okay. Mr. Leonardson, is your client still intending to go forward on the 12th with the hearing?
Yes. However, I received opposing counsel's brief this morning by email, and it would seem to me, if I understand the numbers, that we would have an agreement for resolution. He's indicating that as far as establishing value, well, first off, as far as the witnesses, we have a market analysis by his witness, Chet Wheeler, of a value of $119,000 listed as of October 27th, 2023. If we were to go with that figure, his brief last page shows that it's talking about life estates. I don't believe those are pertinent, but that is using a figure of 92.6% total market value based on a market analysis by his witness. That would be $110,194. The difference in gross would be $23,000. It would be my understanding that, well, I was in real estate for many years, and it would be my understanding that my client is asking for the credit of a potential sale commission, which would be based on the 119, it would be 7140. would leave a net equity of $15,860. 50% of that would be $79.50. Or even of 50% of the gross would be $11,500. I originally offered to opposing counsel a settlement of $10,000 to be paid as promptly as possible, but using a 180-day grace period to complete the transaction. That would or should equate close to the equities that I have given. We disagree with the payment schedule. I show that his client has paid less than a third of the total cost of the property. But regardless of that, or we're prepared to argue that, there's no reason to if we're willing to agree and accept his calculations. So I've talked to my client. I've read his brief. I've talked to my client. My client would offer, even for settlement, a figure of $11,000, which is $1,000 more than she originally offered, with payment within 180 days to resolve the issue. And it seems that would be fair to both parties.
Mr. Thompson.
In terms of that settlement offer, would your client refinance the mortgage and remove my client from the mortgage on the property?
Her intent originally was for payment of the calculation of say the $11,000, which you would refi on a second mortgage, paying her off. But we have to work out, but there would be some sort of agreement between the parties and the mortgagor that she would be removed from the mortgage. Yes, we agree to that.
Your Honor, if they'll take my client off the mortgage and give her $11,000, yes, she'll settle.
Okay.
That's what I understand the offer to be.
You guys
there were a lot of words in there.
Do you guys want to go off the record and you and Mr. Leonardson have a phone call where the two of you can speak candidly, where we're not on the record?
Yeah, I'd love to resolve this, Your Honor, and obviously there's mortgage, there's a couple moving parts. I'd love to resolve this, and if that's the offer, then yeah, let's hammer it out.
Okay. Do you want to sign on? Do you want me to put you guys into a breakout room, or do you want to just call him separately?
I mean, I'm happy to call him once we finish here. I just got a 5-minute hearing next door, and then, yes.
Okay, so Mr. Leonardson, what we're going to do is I'm going to leave the hearing on for now in case you guys aren't able to resolve it. Mr. Thompson's indicating that he's got a hearing he's got to attend immediately after this in district court next door, but then he'll call you, and it sounds like maybe you guys are going to be able to reach an agreement. So let's do that, and then let's see where we go yet this afternoon. Okay.
Okay. My phone number just is,
go ahead.
phone number is area code 989-353-0019, and I will be at it all afternoon. But again, so we understand, my client is willing to offer $11,000 to cash her out and to remove her from the mortgage within 180 days.
Okay. All right. Thank you. Oh, go ahead.
Okay, that's fine. That's the basic figures. We can work out the other details between the two of us. But There was cash out $119 or at the price of $119,000, but her payment to the plaintiff would be $11,000 within 180 days, and a guaranteed removal from the mortgage and the deed.
Okay. Thank you, Mr. Thompson. If you're able to reach agreement, if you could just let the court know this afternoon.
Certainly will. Thank you, Your Honor.
Okay, thank you. That's all for this hearing. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Oh, okay.
This one's Mertz versus. Okay, Mr. Florian, what case are you appearing on?
I am here in place of Andrew Barnes today for Southwest Michigan Asset Management versus Ryan Swope, Sheriff of Crawford County.
Okay, that's our next one. So I'm just going to place you back in the waiting room for just a minute.
Understood. Thank you.
Okay, so we're on the record now in Mertz versus Stop. This is case number 2211282. If I could have both counsel put your appearances on in this file, please.
Your Honor, Caroline Whitmore on behalf of Kai Birdsall, the plaintiff.
And good morning, Your Honor. Nick Artev on behalf of the defendants, Megan Dopp, PAC, and Munson Healthcare, Grayling.
All right, thank you. We're on the record today for a status conference in this case. Looking at my notes, the last time we spoke was back in January. We extended dates out 90 days, and the parties were continuing to work on settlement. Ms. Whitmore, from plaintiff's perspective, can you tell me where things are at?
Recently, well, we're doing expert depositions. Actually, we've got the deposition of plaintiff's expert scheduled, the final one, the orthopedic surgeon. We did send a stipulation to the court earlier this week. I don't know that the court has received it, but we did request an extension of dates for an additional discovery deadline being June 6th with the status conference. With the status conference set for some time in July. There's
Okay.
we still need to obtain the defendant's experts depositions. I believe all that we're going to be taking is an orthopedic surgeon, their expert orthopedic surgeon, if they have one or two. But all of our one of them has been deposed, and we have one that's scheduled for April 26th, I believe.
Okay, Mr. Artev, is that correct from your standpoint as well?
Correct, Your Honor. That's my understanding of where we're at in this case.
Okay, I'm just being informed by the clerk, we haven't received that stipulation extending the dates, but I don't have any issue signing that. So
okay.
I don't think there's anything else we need to do today. The court will send out notice of date and time for that next status conference pursuant to that stiff an order once we get that. Ms. Whitmore, anything else we can address for your side today?
Thank you so much for your time, Your Honor. I'm sorry we had to bother you.
Mr. Artev, anything further from your side?
Nothing further from me, Your Honor. Thank you.
Okay, thank you. You're both free to disconnect.
All right.
Sheriff, are you ready?
I am, sir.
We're a little early. But...
Nope, yep. One table or the other is back.
What's that?
Either table?
Yeah. Okay, we're on the record in Southwest Michigan Asset versus Sheriff Ryan Swope, case number 2311574. We have Mr. Florian here on behalf of plaintiff by Zoom video. We have Sheriff Swope here in person in the courtroom. This is set for an initial scheduling conference in this case today. And so Mr. Florian, can you tell me where things are at from plaintiff's side and how you want to proceed going forward?
So I guess a couple things. I spoke with my partner, Andrew Barnes, who asked me to cover for him today due to a scheduling conflict. We did receive Sheriff Swope, his response. Seems like he's not really contesting the claims. This is a matter for surplus funds following a sheriff sale. In fact, the last line, second to last line of his answer even says that a check can then be made out to Southwest Michigan Asset Management. It appears that he just wants the court to enter that order. I don't know if I did prepare a draft order, if that was something that the court was interested in. I guess I haven't heard from Sheriff Swope with respect to if that's a option he's open to.
Sure.
And it is, I know in the second document that I had filed with the courts was that if the judge was willing to order that money be transferred to Southwest Management, that we're content. And that was kind of our game plan. Once we received those funds, we were going to house them at the Crawford County Treasurer's Office until this proceeding. And if you gave the authority to release those funds to them, that we would do that at that time.
Okay. So Mr. Florian, have you already submitted an order for the court to sign to accomplish that?
I have not, just because I didn't want to jump the gun beforehand. I can either have it sent in today via email or submit it under the 7-day rule. I guess that would be up to your preference.
I think we've got agreement on the record here, so I don't think the 7-day rule is necessary. If you want to submit that, Sheriff, once you see that order, if you have any objections to the wording or anything else, let the court know and then we can address that.
And I guess just while we're here today to clarify that check will be written for $48,751.37.
That is the number that I was given from Attorney Barnes.
Okay. And then
I guess,
Mr. Florian, if you can just make sure to include in that order closing language that it resolves pending claims so we can close the file.
I certainly can. Where would you like the order sent to?
To my office by email, and that's Miss O'Rourke's office. Do you have her email?
I don't believe I do personally. I just want to make sure I get it to the right person.
Yeah, so it's J O'Rourke, OROURKE, all one word, lowercase, at Otsego County MI.gov.
All right, so JOROURKE at Otsego County MI.gov.
Yes.
And Sheriff Swope, do you have an email that you would like me to obviously give you a copy as well?
Yes, please. And my email address is rswope, SWOPE at crawfordsheriff.org. And so we're on the same page, do you want to give some explanation as to how you would like those funds to be sent? Like, do you guys normally want that wired, or do we send it certified mail? How would you guys like that to be written to you once we receive those documents?
I guess I don't have wiring instructions. If you were able to have a check written out and sent to my office, I think that would be at least,
yep,
should be fine on my standards.
Okay, yeah, if you can just in that letter clarify who you would like that check written out to and the address that it needs to be mailed to, and as long as I can get the check written, it'll be out tomorrow.
Okay.
If everything else.
We have our treasurer here now. We started a little early, so.
Yep, sorry.
But don't, that's
That's right. The only thing, Sheriff, is we would request a W-9 to be able to cut that check.
Could you hear that, sir? That we
You
would
need a
request.
W-9 from my client.
Correct. Yes, please.
All right, I will request that, and then as soon as I get that, I will forward that as well over to you, Sheriff Swope.
Okay, and then once we receive those documents, we'll get it cut and get it in the mail. And do you guys want us to do certified mail and give you or do a tracking number so you have it?
That would be fine.
Okay, and I'll have your email when you CC me in that, and then once we mail that, I'll provide that tracking number for you.
Understood. Thank you very much.
Okay, anything else? No. Okay, thank you, Mr. Florian. That's all, and you're free to disconnect at this time.
Okay, thank you. I'll have this sent over to you shortly.
Thanks.
You do that file, right?
Yeah.
Okay. Yeah.
Okay, ma'am, on the iPhone, can you tell me your name, please?
Karen Garrison,
And which case are you appearing on?
Southwest Michigan Asset Management.
We had that hearing at 2 o'clock,
Yes. Is that,
so we've already had that hearing and it's over with now. I'm sorry.
okay? Okay, thank you.
Okay,
Bye-bye.
bye. All right, Mr. Smith, are you able to hear me okay?
I am. Good afternoon, Your Honor.
Okay, good afternoon. We're on the record now in North Branch Outing Club versus Durham. I'm not gonna try and pronounce that second word. So, and Brett Bear. This is case number 2311495. And Mr. Smith, you're appearing on behalf of plaintiff North Branch Outing Club. Is that correct?
That is correct, Your Honor.
All right. This hearing was set for 2:15. It's now 2:18 by my clock. I don't see Mr. Bear or anyone on his behalf signing in. This is notice for hearing today on Mr. Bear's motion to set aside default judgment that was entered previously. I can't remember if it was March or February. And Mr. Smith, I did get your response. I had a chance to review that. Was there anything that you wanted to state for the record today?
No, there's nothing more I think I need to add, Your Honor. Thank you for asking, though.
All right. Based on Mr. Bear's failure to appear or anyone on his behalf, the court will deny the motion to set aside the default. The default will stand. And Mr. Smith, I don't want your client to have to necessarily incur any additional fees, but can you prepare just a very brief order that reflects what occurred today and that the court denied the motion so that we can have that in the file?
And I'm going to write it up that it was denied on the merits, that the judge, that Your Honor reviewed the pleadings of the moving party and the respondent, have that be the basis versus his failure to appear on his own motion, if that's okay.
Okay, and in that case, let me make a few statements for the record then, because I did have a chance to review his motion. I had a chance to review your brief as well. First of all, I don't think that Mr. Bear is in a position to file motions or really do anything with regard to the LLC in this case. Mr. Bear, to my knowledge, is not a licensed attorney authorized to practice law here in the state of Michigan. And so to the extent that there's been any kind of responsive pleadings or motions filed on behalf of the LLC, the court finds that they would not apply. So the court finds there hasn't been an answer by the LLC or a proper responsive pleading and no cause to set aside any kind of default or default judgment entered with regard to the LLC. With regard to Mr. Bear, personally, the court finds number one, that his motion to set aside the default was untimely for the reasons stated by the plaintiff in their brief. And number two, although Mr. Bear, as a non-attorney, may be entitled to some leeway, really there are so many deficiencies with regard to his motion that the court finds that even given an appropriate amount of leeway as a non-attorney, the court would have to rule against Mr. Bear, again, based on the untimeliness, and there really was no showing and no compliance or even really attempted compliance from what I can tell with the court rules in terms of what's required for the court to be justified in setting aside a default or a default judgment. So for all those reasons, I agree with Mr. Smith that on its merits, the motion should be denied, as well as for the reason that Mr. Bear failed to appear today with regard to him personally, and certainly there really can't even be a motion with regard to the LLC. So
Perfect.
that record having been made, Mr. Smith, if you would submit that order, the court will sign that.
You bet. I appreciate your help, Your Honor. I did submit a writ to the court based upon the judgment that is not being set aside. Does your file reflect that? Writ of execution?
Do you know when that was sent?
There was a writ to seize that I,
Oh. 1 second.
that I got on 3/21. I sent it to your office with the check. So I think Jen was gonna hang out of that till after the hearing today to see where that was gonna go. So your
Okay.
office should have that.
All right, so we do have that, and so Mr. Smith, I'll be signing that in the next day or two.
Perfect. All right, then I can get busy. Thank you very much, Your Honor. We'll prepare and submit the order.
Sure, and then one other thing, can you include the closing language in that order, just indicating that all claims have been resolved?
Correct. All claims on the underlying matter have been resolved, but you'll start seeing more stuff from us regarding garnishments and executions. But yeah, that the matter's closed.
Right, yeah, exactly. Okay, great, thank you, appreciate that.
Thank you, Your Honor. Have a great day.
Thank you.